presentation she will be delivering today will deal with competition law and its limits in the sharing economy. So, please, the floor is yours.
Good morning, everybody. My topic broadly is going to be the potential application of competition law within the sharing economy, broadly defined. There is potentially some overlap with the presentation that we've just had, so I will try and find some efficiencies in the delivery. Actually, it fits quite nicely, I think, because what I'm really looking at is if we are opting out of regulation, or if we're deciding against top-down prescriptive regulation, to what extent can the problems we see or potential problems that might arise in sharing economy markets, can we use competition law to actually address these? And this is an interesting question, I think, for two reasons. First, most sharing economy businesses are paradigmatic examples of digital platforms, and we all know that digital platforms are a hot topic in competition law today. We're here to discuss these at this conference. I don't think sharing economy business models have anything particularly interesting or unusual when it comes to the digital platform perspective, but they're an important example to discuss. The second and perhaps more unique aspect when it comes to the sharing economy is the very strong claims that have been made about the unfair nature of many sharing economy businesses, that they are built on exploitation of the vulnerable, that they unfairly exclude other market operators from the marketplace, that they create an unlevel playing field. And one of the questions that has been asked is, if we've got a sort of very clear example of unfair competition, surely can't competition law come in and actually address some of these issues? As the title of my presentation suggests, I think there are some limitations to what competition law can and indeed should do here, but that doesn't mean that we do not have significant regulatory problems that demand other solutions. Very brief overview. Presentation, I'm going to talk generally about competition dynamics in the sharing economy. Then I'm going to look in a relatively doctrinal fashion at the potential application of first the unilateral conduct rules and then the coordinated conduct rules against sharing economy businesses. I will try to do that as quickly as possible. It's quite a detailed discussion, but I don't want to go into too much detail. And then, right at the end, think a little bit more broadly and in public policy terms about the broader limits of antitrust applied within the sharing economy. It's important to emphasize, though, I'm using this term, sharing economy, that to quote Demare from 2015, the main characteristic of the sharing economy is its heterogeneity. We're talking about a very wide spectrum of different business models, of different service areas, and so there's a limit to what we can talk about in the abstract and what we can generalize about. One of the lessons, I think, of the sharing economy is the need to really engage at quite a granular level with what exactly is the market, who are the market players, what are the considerations. How do we define sharing economy? Well, very briefly, I'm going to use the definition from the Commission's communication from 2016. The term refers to business models where activities are facilitated by collaborative platforms that create an open market for the temporary usage of goods or services, often provided by private individuals. Often, but not always. And of course, some of the most prominent players in the sharing economy today often have the provision by private entities, by businesses who are solely involved in these sectors. The Commission definition goes on to identify three categories of actors who are involved in these transactions: service providers who share their assets, resources, time, or skills, users of these services, and the intermediaries that connect via an online platform, providers with users, and that facilitate the transactions between them. We're talking about as I've already mentioned, a very wide spectrum of different services, of different business models. Some of the most prominent that we know today are on this slide: Airbnb, Uber, BlaBlaCar. If you were a true sharing economy scholar and you believed that sharing meant sharing and it wasn't a for-profit business, probably you might dispute the inclusion of any of these platforms apart from maybe couchsurfing within the definition of the sharing economy. Why we'd have tended to focus on these particular entities from a competition policy perspective is, I suppose, it's the commercialized segment of the sharing economy that we're most likely to see the sorts of market problems arising. It's also, I suppose, where we might most legitimately think that we could apply competition law. I think, as we'll discuss particularly when we discuss the unilateral conduct the coordinated conduct portion of the presentation, I have some concerns about what competition law actually has to add here. If we're talking about, reining in part-time Deliveroo drivers, or what, like, is competition already designed for this? But it is something that certainly we can discuss. It's also known, just to flag different terms that are used, the collaborative economy, that's the term the European Commission uses, the peer-to-peer economy, although that doesn't tend to capture those peers who are actually professional services providers, the platform economy, although of course that's way too broad, it catches more than it should, and the gig economy, probably the most contentious aspect of the sharing economy, where we're really talking about how it facilitates flexible working arrangements. That term, flexible working arrangements, of course, it can be a euphemism for lots of different things. Very briefly, some of the competition dynamics that we see in the sharing economy, which are important to discuss because I think they have tended to inform the sorts of competition issues that we see arising. The economic rationale for the sharing economy is the underutilization of durable goods, real property, or man hours, which generates extra capacity that can be rented out. So it's the individual with a spare room that they only otherwise use twice a year. It's the person who works part-time in their job and thus has 20 hours they could spend driving an Uber. This is, from a kind of an efficiency perspective, getting greater utilization of these assets is actually, it prevents wastage of these important resources. It's an economically sensible thing to do. And so I think that we kind of have to applaud that aspect of the sharing economy. How does this take place? Well, we use digital intermediaries, and this is where the technology comes in. We use technologies to match service providers with service users. The intermediaries reduce search costs, and they also facilitate trust mechanisms, that you're not just getting into a stranger's car, you know that that stranger at least has, that Uber has sort of tracked who that stranger is, so you're a little bit more, you're less afraid to do so. An interesting aspect, and this is for competition, the application of competition law in particular, it's important and potentially problematic, is that through these sort of process of technology, the minimum efficient size of the firm reduces to often less than a single person, the kind of turning co's on its head. This causes problems for us because even if we're talking about an individual working part-time, we might still have an undertaking for the purposes of competition law, and therefore we're going to scrutinise their behaviour under Articles 101 or 102. And I suppose the impact of this process is that we both expand the overall size of the marketplace. We bring in providers who might not otherwise be involved. We also bring in consumers who might not otherwise purchase these products or services. I live in London and I would never dream of getting a black cab, but I have to admit I'm quite an enthusiastic user of Uber, even though I don't know whether you're actually supposed to admit that. But it also increases competition because those new providers start to cannibalize some of the demand which was typically serviced by the conventional providers. And that's where we see these conflicts, the claims of unfair competition coming. Just to flag, sharing economy firms are often considered to be paradigmatic examples of disruptive innovation, really changing the rules of the game and not just sort of incrementally improving the products or services offered. And we also see very significant clashes with conventional regulation. Sector-specific rules, like in the transport sector, labour rules, zoning rules, environmental protection rules, tax laws, and you have two very different schools of thought here. On the one hand, there's the argument that the sharing economy, the technology that underpins it, actually renders a lot of conventional regulation obsolete. That you don't need to, if you're a London black cab driver, you don't need to do the 2-year exam that is the knowledge to learn every street in London, because we've got technology that can do that more efficiently. The flip side is the argument that actually a lot of the efficiency that is claimed for the sharing economy is really just finding and exploiting loopholes in conventional regulation. And if we think the conventional regulation is there for a reason, well then we might actually start to be worried about the exploitation of those loopholes. The claim, of course, is that we see significant externalities arising as a result of the emergence of the sharing economy. Okay, antitrust in the sharing economy. Just so we're all on the same page, I'm applying the European Union competition rules and specifically the behavioural conduct rules. So Article 102, the abuse of a dominant position, we need to find dominance and we need to find abuse. or Article 101, and the question being, can we construe sharing economy platforms as involving either vertical or horizontal agreements, and if so, might they be anti-competitive and thus violate Article 101? Let's start with Article 102 TFEU, because I think most of the concern, the valid concerns that have been directed against sharing economy entities are directed against the platforms, the big businesses, Uber, Airbnb. Can we construe these as, I suppose, dominant undertakings violating or abusing their dominance? The first issue is the question of market definition. And here, the very varied nature of the business models we see, of the services that we see across the sharing economy is particularly important. It has to be a fact-specific, case-by-case determination. Sharing economy platforms, of course, comprise two-sided markets. So you've got two discrete yet interlinked sources of demand, and there may be cross-subsidies across the platform, including for some user groups for whom the price is zero. I have to admit that I haven't actually read the new SCOTUS decision yet on two-sided markets, but I think Evans is quoted liberally within it. The relevant players, in terms of defining the market, of course, you've got the three sets of players identified by the Commission, but I think we also do have to think of the potential role for traditional operators within this. Are we looking at just a market for digital intermediation services, or actually should we look at the underlying service market? This was a question that was really put into play by the decision of the Court of Justice in the Uber Spain case a couple of years ago. It's not a competition case, it's dealing with the Information Services Directive, and the question of whether a local municipality can regulate Uber qua transport provider, or do they actually escape regulation because they're just an information services provider. In this case, the Court of Justice actually said Uber specifically, because it so closely controls the behaviour of affiliated drivers, setting prices, terms and conditions, in a very prescriptive way, it said it should be considered a transport provider, suggesting that you would locate it within the underlying services market rather than simply an intermediation services market. In his opinion, the Advocate General did actually distinguish Uber from other platforms where the platform operator has less decisive influence, less close control. The example he gave was booking websites or airline websites, where it's really just matching the service provider and the user. But it does raise the question of whether we should be sometimes maybe considering sharing economy platforms locating them within the actual service market, and not just this sort of abstract digital market. This, of course, is relevant because the market share analysis is going to be impacted by the determination of whether we're looking at a digital market or a digital services market, or we're actually looking at the underlying service at issue. Even beyond market share analyses, though, we need to think about, of course, barriers to entry when it comes to market power. We had a lot of discussion about access to essential consumer data earlier today, and this, of course, is a very contested question. To what extent can it and should it be considered a barrier to entry for these purposes, reinforcing findings of dominance? But other potential considerations might be brand loyalty or visibility, which is important in online commerce markets generally because it facilitates greater consumer trust. One of the reasons people don't shop online is because they just don't trust the online entity out there in the ether. Brand loyalty can be it can be important here. Consumer lock-in, for example, single homing obligations, either at the provider side or at the kind of user side, or even just simply consumer inertia. If you've got the Uber app on your phone, are you always going to use Uber, or are you going to think about shopping around? And, of course, network effects, which have both positive and potential negative impacts if they are going to be reinforcing dominance. It's important, I think, or at least relevant to flag here that there has been some skepticism expressed about whether dominance is ever likely to arise in sharing economy markets. In particular, the FTC had a staff report in 2016 where they basically suggested they didn't really think this would ever be an issue, that you would ever be looking at the application of at least Section 2 in sharing economy sector. Potential theories of harm. First, thinking about maybe exploitative theories of harm, not something that really is a concern or has been a concern in contemporary antitrust discourse up until, I think, quite recently, and the rise of some of the digital platforms. What about excessive prices directed towards final consumers? Well, I don't know whether this is actually likely to arise in practice. practice, because consumers are likely to be fairly price sensitive by their nature. They're not buying the black cab. They're too cheap for that. They're getting the Uber taxi. And there tends to be quite a lot of other options at the kind of final consumer side for switching around. This is, or has, I suppose, been discussed. What has been discussed is Uber's surge pricing mechanism, where on a wet night at 2 a.m. you're going to be charged 3 times the price that you are during the day, something that a normal taxi cab can't do. Arguably, however, this reflects precisely the competitive price matching supply and demand, and so you might have difficulties with the United Brands definition there for the purposes of Article 102. More controversial, and something that was discussed yesterday, is whether excessive indirect costs, for example, excessive data accumulation, might become a problem. And we know that Uber knows things like it knows when you're a 2% battery. It's recently filed a patent to figure out it knows when you're drunk, basically, and you're more likely to not care about the surge price and you just want to get home. Is taking this information and accumulating it, could that be seen as a form of excessive pricing? I think it's somewhat dubious, but it's a really interesting idea. What about for service providers? And this is where we get into the exploitation claims. Either the commission that's been taken is too high, or a more difficult conceptual idea that the Uber sets an unduly low price overall. I think it would be hard to fit this into an excessive pricing claim. Not least because if a platform has risen to the level of dominance, it might be more difficult to argue that price bears no relation to value. Also, we're kind of talking about purchasing an intermediate service in order to provide a final service to the consumers, and what's the consumer welfare kind of trade-off there. But it does bring us back to the argument that the efficiency of many sharing economy businesses may merely be their ability to lower standards, to kind of squeeze the greatest value out of the most vulnerable. In terms of potential exclusionary theories of harm, I won't go through all of these, but possibilities that have been identified in the literature, including things like single homing as exclusive dealing, contracts that reference rivals, MFN clauses. Pina Ackman in particular argues we should be looking at these through a 102 lens. The possibility of raising rivals' costs through things like data collection and algorithmic pricing, such as financial inducements to service providers that currently multi-home. If you basically pay them to single home with that particular platform, could that be a 102 breach? Most controversial, and I think that it is problematic, or I think it's very contentious, this question: could a platform ever rise to, a sharing economy platform ever rise to the level of an essential facility, either for service providers or perhaps some aspects of its technology or even the consumer data it has collected? Could these somehow gain essential facility status? And that's part of a much broader debate about essentiality, indispensability in technology markets. Finally, the argument that tends to be made most obviously about sharing economy businesses is predatory pricing, charging prices that are just too low and no ordinary businessman can compete against them. The difficulty, of course, for our purposes is that under 102, merely taking advantage of a lower cost base isn't going to be a predatory price. It has to be, you have to be losing money as a business to do so. The fact that you're squeezing your suppliers and denying them a living wage isn't really predatory pricing, even though it raises a whole host of other problems that I think the law should be dealing with, just not necessarily antitrust. What about coordinated conduct? Well, there are at least 3 dimensions of potential antitrust problems arising under Article 102. The first would be the possibility that you might have collusion between 2 distinct sharing economy platforms. So this is a hypothetical example, not something I am suggesting is happening, but Uber and Lyft might collude. If you've got a plain vanilla cartel there, the sharing economy, digital economy context, I don't think it makes any difference. It might be difficult, however, to get evidence that it's actually arising. But what about the more triangular relationship between the platform and its users, so the vertical contracts with service providers, or the kind of the idea that the platform might unite at a horizontal level the various service providers? We'll look at the first because I think it's the most interesting, the last of those, that kind of horizontal coordination through the platform in greatest detail, because it is the most interesting from both the conceptual and legal perspective. But before we get to that, it's just I suppose necessary to flag this preliminary issue. are service providers actually undertakings? If we're going to say we've got an anti-competitive agreement here for the purposes of 101, we need 2 or more undertakings. Uber, clearly an undertaking, is an Uber driver or a Deliveroo courier or somebody who rents out their flat for 6 days a year on Airbnb, are they actually an undertaking? The difficulty is that we've got this very broad definition of any entity engaged in economic activity with no de minimis criterion in EU law. And as mentioned earlier, the whole point of the sharing economy is that it reduces the minimum efficient size of the firm. You are an independent contractor, therefore you are, strictly speaking, as a matter of EU law, you're going to be considered an undertaking when you are engaging in those economic activities. You don't even need to be making money. Pure sharing businesses could actually constitute undertakings. So somebody who, out of the goodness of their heart, lets somebody sleep on their couch or sleep in their spare room, could technically be an undertaking. I have no idea why you would want to apply Article 101 to those activities, but in theory you could. The 2 exceptions we might think about are whether we've got an agency principal relationship, and here Spanish gasolineras have very much contributed to the development of the case law, or whether we've got the full self-employed point. I won't go into the agency principal relationship. I think it could actually apply either way. You could be saying one or the other is the agent and one or the other is the principal. I'm not sure, because of the very narrow definition in EU law, that it's plausible. More plausible, I think, is the exception for false self-employed persons, where really the big case is the FNV case. It involved nominally self-employed Dutch musicians playing in an orchestra. The question was, could they engage in collective bargaining, or would that be caught as a cartel between undertakings? The court said if they're really full self-employed, if they're so economically dependent that you cannot say that they're in business of their own accord, then you can take them outside the definition of undertakings. And that, I think, would be the strongest argument for the Deliveroo driver, for the Uber driver. In fact, in the UK in particular, in the realm of labour law, there have been a huge series of judgments coming before the courts, and successfully Uber drivers, Deliveroo couriers, various plumbers, self-employed, have won status as an employee for the purpose of labour rights, not competition law. But there is some precedent there that we should be thinking of these as, we should be looking at their vulnerability rather than the fact that they are nominally self-employed. If we can't get outside 101 for those purposes, we then need to think about how we might run into competition problems. Most interesting is the possibility of a hub and spoke cartel, where you might have coordination between the service providers occurring through what are kind of nominally the vertical conduit of a series of different vertical relationships between service provider and the digital platform. And in this has actually, there is an ongoing, as far as I can tell, it is still ongoing. It's been floating around for a while. There's an actual class action being taken against Uber in the US on this basis, the Meyer versus Kalanick case, where it's alleged that Uber drivers have all colluded over the surge pricing mechanism, and that this is a per se breach of Section 1 of the Sherman Act. They're alleging both the kind of signing up to Uber, but also things like colluding at company barbecues and really random things like that. A tourist case tells us that in EU law, this could be a plausible theory of harm in EU law, and in fact, they don't even necessarily need to meet at a company barbecue if you can show threefold criteria. This case involved an online platform for the sale of for travel agents who all sold their services through this platform. The platform itself took a decision to reduce the maximum available discounts, so sort of quasi price fixing, emailed all the users, all the travel agents who were signed up to the platform. The question was, were they party to a cartel? The Court of Justice said they could be. If you could show the mere receipt of this email with this anti-competitive plan in it could amount to sufficient evidence to show a concerted practice for the purposes of 101, where the service providers were aware of the content of the email and could be taken to have tacitly assented, where they subsequently engaged in anti-competitive conduct, and where you could demonstrate a relationship of cause and effect between the ostensible coordination and future market conduct. Where you don't reach that threshold, it is possible to kind of augment the finding of concerted practice with other evidence. In fact, when the case went back to the National Court on Appeal, the Supreme Court held that that threshold wasn't met for a number of the participants, but it was for others. And so it was sufficient to kind of establish and to sustain a finding of cartel merely by the receipt of the email. Interestingly, in a tourist, and I think important for the purposes of the sharing economy, is that the Advocate General there suggested that where the platform intermediary is acting purely in their own interests, you shouldn't find horizontal coordination. It doesn't make sense. And I think that perhaps that idea reflects a lot of the economic reality of what's going on in sharing economy platforms. If Uber decides that the surge pricing mechanism is in Uber's interests and not necessarily the interest of its drivers, then I don't see why you would construe it as a horizontal conspiracy. The two further cases I think are relevant or worth flagging in this instance. The Via Ramon's case dealt with bid rigging that had been arranged through the use of a third-party consultant to prepare bids. The consultant was engaged by one of the potential bidders, that potential bidder was not aware of anything else that was going on in the background. The bid rigger, the consultant subsequently used that information to fix the bids on behalf of a second party also bidding for the contract, and the question is the first guy party to the cartel? The Court of Justice says they're not if they are unaware of the potential misuse or the future misuse of its data to affect collusion. So if service providers signed up to a sharing economy platform have no idea that collusion is going to be affected, I think Via Ramon suggests that they shouldn't be taken to be party to that. The flip side is the AC Treuhand case, which very firmly establishes that even if you are not involved in the underlying services market, if you have facilitated, if you've organized a cartel on behalf of others who are active in that market, that can be a standalone breach of Article 101. So if we say that a sharing economy platform has, on behalf of its users, organized and implemented a cartel, then they can be held liable for the breach of Article 101. Horizontal coordination, they've got this vertical relationship, still held to be a cartelist. It is something that is perhaps more discussed than, the Arturis case is interesting, but it is something that I think exists more in theory than in practice in many instances. If we don't have a hub and spoke cartel, we don't have cartel conduct, we might still, if we can show a degree of horizontal coordination between the parties who are affiliated with the platform, we might still have a problem. I just wanted to flag, I suppose, three considerations for trying to determine whether horizontal coordination through a platform might amount to a breach, either an object or effects-based breach of Article 101.1. First, it's important to emphasize the kind of two-sided nature of platforms again, platform competition, and the ever-important carte bancaire case, which of course dealt with a two-sided market. In carte bancaire, the Court of Justice developed a distinction between restrictions of competition and harm to competition, and in particular emphasized that in a two-sided market, the former may not lead to the latter. The mere fact that you're restricting competition on one side of the platform doesn't necessarily mean that we're going to have harm. On the other hand, in the MasterCard case, the court did emphasize that serious harm to consumers on one side of a two-sided platform isn't necessarily going to be compensated by the availability of a valuable product to consumers on the other side. We might also think about the ancillary restraints doctrine. Is surge pricing necessary to make the Uber platform work? But that's very narrowly construed in EU law. And important to think about the Article 101.3 criteria. Is there a case for a more affirmative action application of the exception rule in the digital economy? The Luxembourg Competition Authority a couple of weeks ago, I think, actually explicitly approved of some algorithmic collusion mechanism between taxi providers in Luxembourg, not under EU law, but under Luxembourgish competition law. So I think they were sort of online taxi providers, or taxi services providers, suggesting that maybe there is more scope. I don't know if I would read too much into the kind of activities of such a small jurisdiction, but an interesting example. Outside the horizontal context, vertical restraints? Could we construe agreements between the platform and its service providers as vertical restrictions? The law in this area is very much moving. A couple of cases 6-7 years ago, which seemed to take a very restrictive approach to vertical restraints. The Football Premier League case, for instance, Pierre Fabre. In more recent years, we have cases like Maxima and Coty, which suggest a much more nuanced consideration of the treatment of vertical restraints under Article 101. Just to kind of flag some, I suppose, particularly relevant points in terms of the sharing economy, given the need to establish a thick market, lots of providers, lots of users, certain conventional vertical restraints, which would restrict sort of retail level competition, don't really make sense here. But you do see the use, or at least the potential problems of certain restraints, such as the use of MFNs, bans on multi-homing, perhaps potentially the tying of services. So if in order to sign up to a ride-sharing platform, you have to use their insurance, could that be a tying issue? And the big concern would be resale price maintenance. Even though we don't really have resale here through the intermediary, the very broad wording of Binon from an old case at this stage, 1985, which said that provisions which fix the price to be observed in contracts with third parties constitute by themselves a restriction of competition within the meaning of 101.1 would seem to catch any clauses like the price surging mechanism or Uber's pricing policy generally, which dictates the price that the service provider must charge to users. Literally, if you're reading Binon literally, and 101.1 literally, as Binon did, obviously. I think this orthodoxy can be challenged by Maxima in particular, or the more thoughtful approach in Coty, but I won't go into details on that. We can discuss it later. Finally, in like 30 seconds. There's only 2 slides. The limits of antitrust in the sharing economy. I think you've maybe getting already that I don't know how useful antitrust is to solve a lot of what we see as the most urgent problems in the sharing economy. This was a strike by taxi drivers in London in response to Uber, this picture comes from. There is obviously this very obvious positive correlation of sharing economy businesses towards overall competition and consumer welfare, at least in the antitrust sense. Do we think that consumer welfare should care about how, the service providers' livelihood? Is that something that we should take into account? Maybe, but do we in the conventional antitrust sense? No. We use the term efficiency all the time, which obscures how efficiency is often realized in businesses. It very clearly generates negative impacts for 2 sets of players: established providers displaced by new entrants, and certain categories of more vulnerable new providers. Unfortunately, from an antitrust perspective, there's a very strong argument that these are merely examples of aggressive yet healthy and permissible competition. The kind of, Advocate General Vol has a very particular vision of what EU competition should be seeking to achieve, but I think he's right here. The renewed commitment to fairness, is that going to be helpful to us? Well, almost certainly not. Commissioner Vestager clarified earlier this year that what does fairness mean? It means ensuring that markets stay competitive enough to give consumers the power to demand a fair deal. Consumers are already getting a fair deal in the sharing economy. And so is that going to help us? I don't think so. Providers maybe are not getting a fair deal, but is that something competition can do? And I won't go into these in any detail, just to flag one of the big concerns, which is the kind of the asymmetry that's created between conventional regulation of some sectors and the use of technology to exclude that. The lack of a level playing field between established providers and new entrants, I think, does exist, but surely the answer cannot be a levelling up of regulation that no longer has a role in society. So you don't need to regulate Uber as if it's a taxi provider, because a lot of that regulation just simply no longer makes sense in 2018. On the other hand, the fact that underlying public policy goals are not protected, some of these concerns can be addressed by the technology. So the fact your taxi driver, it doesn't need to do a long course to figure out where to go because they've got a smartphone. Some of them are not, and I think that we need to think about how labour law addresses these issues. We need to think about how tax law addresses these issues. We need to think that there are still aspects of, say, the regulation of mobility, as very clearly seen by the saga of Uber in London, and the fact that it was doing things like systematically under-reporting alleged sexual assaults by drivers. We still need regulation there, I think. I'm just not sure that antitrust is how we regulate. Thank you. I very much agree with you on the Uber example. And the court, in fact, even though it's not a competitional case, in Uber Spain used the language of decisive influence. So it used the competition language and ports it into this particular area. It's just that Uber has a very particular business model. It's incredibly prescriptive. Between the platform that is Uber and the platform that is Booking.com, you've got a very wide spectrum, and that's where I think we've got the scope for argument. Airbnb, somebody who rents out their flat on Airbnb, are they an undertaking? Airbnb doesn't set the price. It does set some terms and conditions, but it's not very prescriptive. I was trying to find an Airbnb that had like a carbon monoxide sort of tester in a particular town where I want to book one. It's very hard to find. Like they don't harmonise what you have to offer. You just basically have to offer somewhere that's reasonably clean and reasonably safe, I think. So I don't think that the conversations are relevant. I think it's irrelevant to Uber, but it's maybe not outside. Yeah, yeah.
Okay, I have to stop it here right now. I'm sure the discussion will be very